5 seconds to go. Start. Both suits, that is, the 1995 suit and KIC suit first, were tried together and disposed of by common judgment. It was held by the trial court that the appellants herein could establish their continued, unhindered, and unhampered possession, cultivation, and enjoyment of the suit schedule property since 1929 till date of judgment, and that they had preferred title against the Karnataka government in 1963. It was also held that hence the government had no rights and title over the suit schedule property on the date of grant, that is, on 25th March 1968. It was further held that when the government itself has lost the title and right over the suit schedule property, it has no right to grant the suit schedule property to the fifth defendant. The defendants never in possession of the suit schedule property. For the same reason, KIC's suit was dismissed. It was held that the grant in its favor was ineffective as the Karnataka government had no power to issue it, and further that KIC was never in possession. KIC and the other aggrieved parties, including the other respondents in the 1995 suit, appealed this by preferring RA number 31 of 1998. This common appeal was disposed of by judgment and decree dated 3rd March 1999. The appellate court noticed that the findings of the trial court in KIC suit first were unchallenged. KIC had relied on a document to say that the lands were converted. The appellate court, while dismissing the appeal, held as follows. The appellant corporation contended that the suit land was got converted by the conversion sanctioned certificate said to have been issued by Tehsildar dated 18th December 78, and a copy of the said judgment is marked as Exhibit D4. In my considered view, no reliance can be placed upon Exhibit D4, which is much disputed by the respondents because it is only a Xerox copy and the appellant has failed to produce the original of the same before the court. On the other hand, Exhibit P1 is an endorsement issued by the Assistant Commissioner Bangalore dated 27th May 1809, which reveals that the proceedings regarding conversion of land are not available in the office. Hence, I find some force in the arguments of the respondent that Exhibit D4 is a got up document. If the suit land was really got converted, the appellant could have produced the certified copies of relevant documents from the Revenue Office. It appears that Exhibit D4 is a fictitious document and there is no order for conviction of land as contended by the appellant. Hence, the entries made in the relevant RTC records that the land was converted are incorrect and false. The RTC extracts for the year 1983, 84, 84, 85 reveal that 4 acres of land is under cultivation, but the name of cultivator is not mentioned in cultivators column. It is not the case of appellant that it cultivated the land during relevant period. Since the finding given in OS 21 of 96 remained unchallenged, I am of the considered view that it is the respondents who are in physical possession of suit land, and trial court is justified in granting the prohibitory injunction as against the appellant. The declaration granted in the 1995 suit by judgment dated 31st January 1998 that the appellants herein were absolute owners was set aside. However, it was held that KIC's grant had been cancelled. The decree of permanent injunction was, however, confirmed. KIC had also preferred a second appeal in which the judgment of the first appellate court in RA number 31 of 1998 was impugned. KIC's second appeal was dismissed by judgment dated 16 June 2005 by the Karnataka High Court. The High Court categorically held that a deemed cancellation of the grant of land in favor of KIC had occurred as due procedure had not been followed while making the alleged grant. The High Court held, in view of the detailed discussion made above, while answering the substantial question of law raised in favor of the respondents, it is held that both the courts below have rightly come to the conclusion that the plaintiffs' respondents are in possession of the suit property and thereby rightly injuncted the appellants from interfering with the peaceful possession and enjoyment of the suit property, and that there is deemed cancellation of the grant of land granted in favor of the appellants, and that due procedure has not been followed while making alleged grant in favor of the appeals. Stop.